All right, let's talk a little bit about the enforcement of the Fair Housing Act. The Fair Housing Act, obviously remember that the Fair Housing Act was passed originally in 68. It was Title 8 of the Civil Rights Act of 1968. Do not confuse that with the Civil Rights Act of 64, which basically was non-discriminatory across the board. The housing was 68. All right. It is enforced by the Department of Housing and Urban Development and the Department of Justice and any state and local fair housing enforcement agency or any private lawsuits in the federal and state courts. Okay? So it can be maintained by anybody. And I guess that's wrong. Let me go back. There are multiple people that have jurisdiction. That's a better way. You got HUD, you got your DOJ, you got that state Indianapolis Fair Housing Office, and you've got private lawsuits. All of those are potential ramifications of the problem. Now, here's the big problem, in my opinion, that you have to keep in mind. That this is a outcome law and not an intent law. What I mean by that is, under the law, even people that do not mean to discriminate are still responsible. Even if the person intended something good to happen, they can still have been found if they acted illegally. So what I mean by that is, let me give you a great example of this, all right? Now, I have to go back a couple years because a buddy of mine and I were sitting in having cigars, which is my favorite pastime, and probably not good for me, but that's okay. It was right when the Olympics, and you guys remember Usain Bolt from Jamaica was running, and he was breaking all the records and winning all the speed records. And I'm not even going to mention his name because I don't want it to potentially get out. But he looked at me and he said, yeah, he said, did you hear Usain broke the record? And I said, yeah. And he goes, but of course, you know, they're all fast. All right. Now listen to what he said. He said, they are all fast. And I looked at him and I'm like, okay, who are they? Or what are you implying? And he said, sprinters. I'm meaning that all of the sprinters are faster than me, so they're all fast. But he happens to be really fast. I said, oh, so you're not implying that you meant African Americans were faster than white? Oh, God, no, that's not what I meant. Okay? That is a great example of the intent versus the outcome are completely different. You guys are subject to the outcome. How does it feel? How did it make the person feel? So you could, okay, Dave, you're sitting here. Now I wear glasses. I see you got glasses on. I only wear glasses for a distance, for like driving in movie theaters and stuff like that. But let's just say I was trying to be funny and I said, hey, Dave, we know that people that wear glasses are always 20 IQ points lower. And I was trying to be funny. No, seriously, come on. But if you felt offended, you potentially could be able to file a lawsuit. That's the problem. This is not an intent law. You cannot stand in front of the judge and go, hey, Your Honor, I didn't mean to hurt his feelings. That's not the point. The fact is you said something. That's a problem for me because it's always hard to disprove how someone else feels when something comes up like this. You can't say, well, that's not what you felt. Yeah, it is. That's how I felt. I felt degraded. I felt insulted. I felt embarrassed. I felt ashamed. I felt mad. Whatever. You cannot defend against that. All right? So you've got to be really careful on how that goes. Now, there are some time frames. For instance, it's 180 days for the state or local law complaint or a lawsuit. All right? It's 1 year if you want to complain to HUD, and it's 2 years for a private lawsuit. The DOJ has no limit. All right? So a state or local complaint, which we would have a state or local complaint, is 180 days, 6 months. If you're going to complain to HUD, you've got 1 year. If you're going to file a private lawsuit, you've got 2 years. And the DOJ has no limit but there has to be a pattern and a practice for that lawsuit to happen. So basically, they have to find that there's a pattern in that. Now, here's one of the ways they're going to get you. Thing called a tester. All right? Testing is a means of uncovering evidence of a race discrimination in rental housing or shopping, as it's sometimes called, finger quotes, shopping. They're going to shop you. All right? And it's not just race discrimination. It can be any discrimination, all right? Testies. Whole different topic. Never mind. Testers are usually local individuals from the community that have been trained to conduct these fair housing audits or tests, all right? So it's local people. It's not anybody that they're going to ship in or bus in from Washington, D.C. to test Omaha, Nebraska. They are going to hire local people. And what these people do is they use standardized forms that report what transpired during the test. All right? So, like, what was the nature of the assistance? And there are some, they don't write in, it was good. They would check good, bad, poor, or, helped by this. That way, it's apples to apples. You don't get one guy going, it's not as subjective. It's very objective, where they can grade it. What was the nature of the assistance? How many people assisted you? What was the type of the units that you were shown? So if you show that person and say, okay, here's all the floor units. I see you're in a wheelchair, so we're not go upstairs. That could be a violation. What were the terms and conditions, so that to make sure that you're not offering different terms to someone that may be in a protected class, and so on. The federal and state investigate and enforce these agencies, such as HUD and the DOJ, make sure that these testers complete what they're supposed to do. Now, testers can also use secret video and audio, as long as the jurisdiction allows that. In Indiana, only one person knows they're being audited or audio recorded is required, okay? Not a practicing attorney, but I did sleep in a Holiday Inn Express. What I'm telling you is, as long as one person in the conversation knows it's being recorded, then they don't have to disclose that. Now, video, I think they have to tell you, hey, you're being videotaped. But if they're talking to you with an audio, they don't have to. I got that call the other day. I got on the phone and he goes, your recording may be called for quality and training purposes. And I was pissed, and I forget who it was. I think it was AT&T, and I called them and told them, said, I was recording this too. And they literally asked me, can you turn your recorder off? I said, no. And she said, well, then we're instructed not to have any conversation. You need to call back. And I'm like, well, maybe I want quality and training with my family. So, we all know why they're recording that, okay? Also, testers' identities are typically kept a secret, all right? Now, if that case goes all the way to court and litigation ensues, then the identity of that tester will become known, because they may have to come and actually be involved in the court case by giving evidence or being cross-examined, subpoenaed. So typically it is a person that has been secret, okay? Now, how does the procedure work? That's great. So first of all, there has to be a complaint to HUD, all right? So if a complaint is brought to HUD's attention, the first thing they do is they were going to assist this person in making sure that how they fill the claim out, and whether or not it actually falls under the fair housing realm. So what I'm talking about is, maybe they're going to call and say, hey, well, I couldn't get into this manager's apartment because there was no handicap parking spot. Well, that may be an ADA claim, actually, and not necessarily a fair housing claim. So that's the first thing that they're going to do. The process involves about 5 or 6 or 7 steps. The first step is called the intake process. The intake process is where a person files a claim, and then HUD determines if they take all the information, they think about it, and determine if there's a claim to be made. If it's a state that has like its state office, they would then pass it down to that state office. So if it was from Indiana, it would go to HUD. HUD would then pass it down to the state. If HUD does that, they can move to step 2, called filing an actual complaint. So in the intake process, they're going to determine, let's say, hey, this is an issue, we need to do that. They will then actually file the form or file the complaint on one of their forms so that it fits the paradigm of a HUD document. Then what they'll do is they'll send that back out to the person filing the claim and say, okay, here's what the claim you made, here it is on our form. That person then has to mail that signed claim, that signed a grievance back within 10 days. So even though that they may file a complaint in the intake process, it has to be on a HUD form for it to actually work. And HUD will do that if they deem there has been an actual grievance or a violation. They'll fill all the form out. They'll send it back to the person and say, here, sign this, send it back to us. Okay? Then there's the investigation. This is the collection of all the data. This might involve conversations with both the respondent and the accused. It may involve the testers. It may involve conversation with a tester. It may involve litigation, all of that. Now, if they see that there's a problem, the first thing they're going to try is this thing called conciliation. That's step 4. Conciliation basically is where you guys hug and make up. Kiss and make up, say you're sorry, let's solve this problem and move on. If both parties agree to the conciliation, then no more work is done and the complaint is closed. All right? So conciliation is the first step. Now, after that, if conciliation does not work, let's say one party or the other, one denies the claim. Hey, you're being accused of this, and the property manager denies the claim. It will then go on to one of 2 outcomes. Either is going to be a no-cause determination or a cause determination followed by a charge against the defendant. All right? So the plaintiff's going to make this allegation. What they're going to try and do is say, okay, tell them you're sorry, it's never happen again. And then it's either, if that doesn't work, it's then either going to go to a no-cause determination where they say, okay, we actually have reviewed this and determined that there was not a violation, so there is a no-cause determination. We believe that the defendant did not violate the fair housing law, and that's the end of the case. Done. All right? Now, if they actually file and find a cause and say, yes, we do believe that this was a problem, and the defendant is in fact in violation, then there is a cause determination created, and then they will move to the next phase, which is charges. And here's the charge that's being levied against you. All right? Now, in the class, we actually go through the pricing structure, and which I think is dumb as hell, because I think the first violation, I can't remember, it's like 11,500 or 16,500. And the reason I don't know is because I've been teaching so long, that number's changed. The second one is higher. The third one is higher. The point that you're getting at is one of 2 things. One is if you have 3 fair housing claims against you, dude, you need to rethink your job. All right? Second is each one is progressively worse. That's the big thing. So the first one, even if it's 11 or 16, doesn't matter. The second one's like 23. The third one's like 55. So it's progressively worse and worse and worse. So you should hopefully learn your lesson the first time, okay? So those are the steps that happen. Now, the DOJ can actually have an enforcement. All right, they have the right to file an independent authority to initiate a lawsuit if they're alleging a pattern or a practice of discrimination, or a denial of rights to a group of persons that raises the issue of a general public importance. Got it? Sweet. What I mean by that is, if this person, let's say they've had 3 or 4 or 5, and they see a pattern or a practice that this person is traditionally, not traditionally, that's a bad word, consistently discriminating against the handicapped, then the Department of Justice can come in and file a lawsuit as well, claiming that this isn't like a one-off. You didn't make a mistake. You actually have a practice or have established a pattern of discrimination. Typically, their remedy is some kind of injunctive relief, meaning they want them to stop doing something, okay? It could also be monetary damages for the aggrieved person, and they can assess civil penalties. Typically, there is no criminal penalty, so they're not going to really do time. So if there's a pattern and it's a general public importance, the Department of Justice can come in and file for an injunctive relief. One of the big ones is, remember we talked about the building. They've got to be built a certain way after 91. If there is say an apartment complex builder that is consistently building units that do not meet the handicap standard, and they've built several of them where they can perform where the DOJ has a pattern, they could potentially serve them with an injunctive relief that says you need to stop building all buildings because you have proven that you cannot do it correctly. And they could also file monetary damages and any civil damages. All right. Now, there's also some direct court actions that can happen, and I don't really want to get into any of the private lawsuits, but there can be civil lawsuits if someone feels aggrieved. They can take them to a court, either a superior or a local court. If it's a race case, it automatically goes to federal court. It skips all of the low-level courts, all right? I don't think anybody would appreciate that in there if we call them, Superior Court as a low-level court. But it would go to a federal court case. So anytime that there's a violation based on the Civil Rights Act of 1866, which is the race card, it would automatically go to federal court. All right? Any questions? I know we're getting real close. Bear with me here. We got just a couple more things I want to talk about. We're going to come right back.